Speaker, I present a legislative statement on the Sentencing Reinstating Three Strikes Amendment Bill.
That legislative statement is published on the authority of the House and can be found on the Parliament website.
I move that the Sentencing Reinstating Three Strikes Amendment Bill now be read a second time. Mr Speaker, this bill gives effect to the Government's coalition and manifesto commitments to bring back the Three Strikes sentencing law as a key priority in our work to restore law and order. Reinstating the Three Strikes law sends a clear message to offenders that there will be significant consequences for serious repeat offending and that we denounce their actions. It recognises the harm to victims and communities that results from violent crime and makes it clear that this will not be tolerated. I also note that keeping these repeat offenders off the streets will contribute to this Government's commitment to 20,000 fewer victims of violent crime by 2029. In broad terms, the bill will reinstate a three-stage sentencing regime with the offender facing increasingly tougher penalties at each stage. It will have the same overall structure and essential features as the previous regime. In general, offenders will be warned of the consequences of reoffending at their first strike and will not be eligible for parole at their second strike. For a third strike, offenders will have to serve the maximum penalty for the offence without parole. Mr Speaker, the bill has now been reported back to the House from the Justice Select Committee, and I would like to thank the Justice Select Committee for its careful consideration of the bill and the submitters who shared their views with the committee. Mr Speaker, in response to public feedback during the Select Committee process, Cabinet agreed to propose two changes to the bill for the Justice Select Committee's consideration. I welcome the committee recommending that these significant changes be made to the bill. I note that although these changes involve substantial drafting, they deal with clear situations. The first significant change lowers the qualifying sentence threshold to above 12 months imprisonment at Stage 1. Lowering the qualifying sentence threshold at Stage 1 addresses public feedback to make sure the regime properly targets serious offending, so serious violent and sexual offenders face appropriate consequences. While this lower threshold means more offenders will receive first warnings, there will continue to be the higher threshold of above 24 months imprisonment at Stage 2 and Stage 3 that must be met to trigger the regime's mandatory sentencing consequences. The Government considers this approach addresses public feedback and strikes an appropriate balance by ensuring the regime continues to be workable in practice and does not capture low-level offending. The bill also contains additional technical and procedural changes relating to these amendments. These other changes mainly address when an offender has a conviction overturned or receives a new sentence above or below the qualifying sentence threshold after an appeal. For example, depending on their exact situation, an offender could either be given or lose a warning. These changes also address when an offender with a first warning reoffends and meets the threshold of above 12 months imprisonment for a first warning, but not the higher threshold of above 24 months imprisonment that triggers mandatory sentencing consequences. In this situation, an offender will be given an additional first warning to reinforce the mandatory consequences they could face if they reoffend. Mr Speaker, the second significant change to the bill involves reactivating warnings issued under the previous regime. This change addresses public feedback about making sure previously warned offenders face further consequences if they reoffend. The Government considers this change is appropriate to make sure offenders' warnings still count and are included, where appropriate, in the new regime's consequences. However, the bill provides that previous warnings will be reactivated only when they meet the qualifying sentence threshold. I consider this supports a consistent approach in how the new regime treats serious offending, even where that offending occurred during the previous regime. The Justice Select Committee also recommended further amendments to the bill to give effect to this change. These amendments set out how previous warnings will generally be treated under the new regime. For example, an offender's previous first warning will be a first warning under the new regime if their sentence is above 12 months imprisonment. The bill also provides for exceptions to this general approach. For example, an offender's previous final warning could instead become a first warning under the new regime. This could occur when an offender's previous first warning does not meet the qualifying sentence threshold. Additionally, the bill confirms reactivated warnings are valid and not affected by how an offender was originally warned. The bill's existing appeal provisions also apply to any appeal against a reactivated warning. For clarity, I note the bill's mandatory penalties will continue only to apply to sentencing for offences committed after the new regime comes into force. Any offences committed between the previous regime ending and the new regime beginning will not be captured by the new regime. Mr Speaker, in addition to the significant changes I've outlined, the bill has also been amended to reflect other recommendations by the Justice Select Committee, and I wish to briefly highlight three such amendments. Firstly, the guidance for the judiciary about applying the manifest injustice test has been clarified. In particular, the bill now expressly states that a court remains able to consider the mitigating factors in the Sentencing Act when assessing whether manifest injustice applies. Secondly, a person loses a warning when, in accordance with the bill's stipulations, they are granted a pardon for an offence they got warned for. Removing a person's warning is appropriate where a miscarriage of justice has occurred. Lastly, the bill also clarifies how the new regime interacts with post-conviction orders granted under the Criminal Procedure Mentally Impaired Persons Act 2003. A court cannot issue any order that would replace an offender's sentence of imprisonment when the offender is facing the regime's mandatory consequences at either Stage 2 or Stage 3. And in regard to commencement, Mr Speaker, there is a 6-month implementation period before the regime commences to make necessary operational changes. Mr Speaker, ACT campaigned to reinstate the Three Strikes regime, and this forms part of our coalition agreement, supporting this government's commitment to restore law and order and to keep our communities safe. The bill, as reported back, ensures there are tougher consequences for serious, repeat, violent and sexual offending. I believe this supports the public having confidence in the new regime and enables law-abiding New Zealanders to feel safer. Mr Speaker, I commend this bill to the House.
I have a feeling that that bill completely misses the part about how to actually do this. Victims of people who have been subjected to Three Strikes events will not have any influence in the say of what happens when it comes to parole hearings because they're going to be gone. As a result, when that person is released from prison, they could effectively cause problems, stalk offenders, do all sorts of things there, and have very little redress to the victims. I feel that this bill itself has missed what it's trying to actually take on board. That's my context worth.
Yeah, I mean, I looked at some of the papers that came out of the United States because that's where this idea comes from. It comes from the United States, in particular from California. What studies have found is that, yeah, there's a reduction when it comes to burglary. There is no reduction when it comes to murder and sexual assault. So if this bill is designed to address serious crimes, like last time, it will fail to do that.
Especially considering, based on a first or second strike sentence that is, say, murder, well, if it's murder, the only sentence a judge can issue is life imprisonment. The only thing that they have control over is the thing called the mandatory non-parole period. And the thing is, that will be the only Three Strikes punishment that will actually have parole conditions that actually belong beyond release, because when you're life imprisonment, you are forever on the life and parole, forever monitored once you've been allowed back into society.
I hate the idea of treating prison as a place of punishment. It should be treated as a place where people are put into essentially state care because they have violent tendencies. We've got to really get away from this idea of punishment because what are we doing? What does punishment mean? It means withholding of care. It means withholding of rehabilitation, and then we release these people back out to the public over and over and over again, and they just create more victims.
Three Strikes will deliver. Alex, you've been quiet.
I'll just say the bill shouldn't be. I have concerns with the bill, and it should be stopped at all costs if possible.
Unfortunately, it's past third reading.
So, and I think I'm trying to remember another group. They call themselves People Against Prisons Aotearoa. They've got concerns on whether Three Strikes work at all as well.
Well, it removes two fundamental positive aspects of our prison system. So, the parole board, it removes that check and balance in place on society. That little, you can keep control of that person and make sure that they don't reoffend. Three Strikes basically sits there. Once you're on second strike, you're released. It's like, here's the keys to reoffend.
Yeah. Nowhere in the bill does it mention rehabilitation.
Yeah, and also if you're on a Three Strikes punishment, are you going to be denied rehabilitation while you're in prison?
Don't know.
Yeah, considering usually those rehabilitation courses are used to try and actually get you on parole.